All right, welcome to our reading of Dred Scott v. Sanford, which is a U.S. Supreme Court decision. So the way that this is going to work is that I'll read until we hit a line across the text, and then that's the point where I'm going to stop and talk about what we just read for a little bit. And then I'll go back into the text and we'll continue on that way. As we go, you might see some margin notes. By the way, those are my notes for myself to just help me make sure that I'm remembering everything I want to say. All right, so without further ado, let's go ahead and start with this part in the italics, which is an introduction. So it's just going to tell us a little bit about the text itself. The decision reached by the Supreme Court in the Dred Scott case in 1857 is one of the most notorious rulings in the court's history. Chief Justice Roger B. Taney, who wrote the majority opinion, declared that all blacks, slaves or free, were not and never could become citizens of the United States. The decision also made the 1820 Missouri Compromise unconstitutional and permitted slavery in all the country's territories. The case in which this appalling decision was made was an appeal by a slave, Dred Scott. Scott's owner had taken him into Illinois, a free state, and the territory of Wisconsin, also free, before moving him back to the slave state of Missouri. Scott argued that his residence in the free parts of the nation undid his status as a slave. Taney, speaking for the court majority, decided against him. Abolitionists were furious, and the decision further divided the sides in the national debate over slavery. All right, so this decision happens just ahead of the Civil War, right? The decision is 1857. The Civil War breaks out in 1861. So we're just a hair ahead of the Civil War as tensions in the U.S. over slavery are getting to their height, right? So people are really, really fighting and arguing about this. This is the point where we've got fights literally breaking out in Congress over it. We've got lots and lots of back and forth about it. And abolitionists are doing everything they can to try and end slavery. Okay? And so Dred Scott is a black man. He's a black man who moved through some different free states. And he said, hey, look, I lived in those free states for a set length of time. I did, my wife did, our kids did. We should be free people because we resided in free states. Okay. This is actually in direct contradiction to the fugitive slave laws if you stop and think about those. So that's part of some of this context, right? And the fugitive slave laws mean that if slaves run away from their owners and go to free states, they can be recaptured and forcibly re-enslaved no matter how long they lived in those free states. The only difference with Scott's case is that he was taken there, he went willingly and with his slave owner. So he's not traveling all on his own there like escaped slaves would. Okay. All right, on to the text. The plaintiff, Dred Scott, was, with his wife and children, held as slaves by the defendant, Sanford, in the state of Missouri, and he brought this action in the Circuit Court of the United States for Missouri to assert the title of himself and his family to freedom. The declaration is that he and the defendant are citizens of different states, that he is a citizen of Missouri and the defendant is a citizen of New York. The question is simply this: can a Negro, whose ancestors were imported into this country and sold as slaves, become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen? One of which rights is the privilege of suing in a court of the United States in cases specified in the Constitution. All right, so these three paragraphs really go through handful of things, right? Who were Scott and Sanford compared to each other, right? And then just a touch, not much, just a touch about their background, right? So Scott is saying he is a citizen of Missouri, and that the defendant, Sanford, his owner, is a citizen of New York, right? So the question is this: can black people whose ancestors were imported and sold as slaves become a member of the political community? Can they become citizens, okay, of the political community of the United States? Okay. Can they constitutionally become citizens? And as such, are they then entitled to all the rights, the privileges, the immunities that you and I enjoy as citizens? Okay. Or at least as residents of the United States. Because this is one of the aftermaths of this decision. In later on, we'll find out with the 13th Amendment and the 14th and 15th Amendments, is that everybody who lives in the United States is going to be entitled to certain privileges, whether you're a citizen or not. We're also going to fix this citizenship question. Right? So one of those rights is the privilege to sue in U.S. court. Okay. So is Scott a citizen? And as such, does he have the right then to sue in federal court? Okay. By the way, as we go, before I dig into the text, you'll notice some words are bolded. Right now I haven't mentioned it because this is the first one we're going to come across. Those are defined down at the bottom of the page. So if you don't know what they are, those little numbers will tell you which one of these definitions to look at. And these are called footnotes when they're at the bottom of the page like that. Okay. It's a pretty common text feature of nonfiction text. All right. So the words people of the United States, and I'm back on the text now, and citizens are synonymous terms and mean the same thing. They both describe the political body who form the sovereignty and hold the power and conduct the government through their representatives. The question before us is whether the class of persons described in the plea of abatement, people of African ancestry, is who we're referring to, compose a portion of this people and are constituent members of this sovereignty. We think they are not, and that they are not included, and were not intended to be included, under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered a subordinate and inferior class of beings who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges, but such as those who held the power and the government might choose to grant them. Okay, so in this paragraph, got some really key points, right? First of all, we're talking a little bit about the class of people. Okay, so not just Dred Scott himself, but the group of people that he is representative of. In this case, people of African ancestry. Okay? And he's again posing that question, are they citizens? Okay. He says, no, they're not. They are not now, nor did the founding fathers intend to include them, okay, under that definition of citizen in the Constitution. Okay. In no uncertain terms, that's what he says. Right? And he says because they are not included in that definition, they also don't have access to the same rights and privileges. Okay. He says, on the contrary, so as opposed to being citizens, right? They were at the time, so back in 1787 when they're writing the Constitution, they were considered to be subordinate and inferior beings. that is, lesser people, okay, who had been subjugated by the dominant race. Okay. They had been enslaved, okay, put under control. They were controlled by the dominant race. And whether emancipated or not, emancipated means freed, yet remain subject to their authority. So whether they're free or not, they're still under the authority of white people. Okay? And they have no rights or privileges, but such as those who held the power and the government might choose to grant them. So think back to when we were reading a little bit about the Constitution, right? And we were reading the Declaration of Independence. And those documents talk about everybody being equal, right? Our rights coming from God. That's, he's saying, well, if you're included in the citizenship, if you're the white people, yes, that's the case. If you're not included in the citizenship, right? If you're Black people, that is not the case. You don't get those same rights. They aren't granted to you by God, but instead by the government. Okay, so he says flat out right at the beginning, Scott is not a citizen and doesn't have the same rights as citizens. The court thinks Dred Scott could not be a citizen of the state of Missouri within the meaning of the Constitution of the United States, and consequently was not entitled to sue in its courts. It is true, every person, and every class and description of persons, who were at the time of the adoption of the Constitution recognized as citizens in the several states, became also citizens of this new political body, but none other. It was formed by them and for their posterity, but for no one else. And the personal rights and privileges guaranteed to citizens of this new sovereignty were intended to embrace those only who were then members of the several state communities, or who should afterwards, by birthright or otherwise, become members, according to the provisions of the Constitution and the principles on which it was founded. Okay, so he says Scott can't be a citizen of Missouri, and because he can't be a citizen, he's not entitled to sue in the courts. So he doesn't have a right to sue just because he exists, right? And then they go on to define how they're going to figure out who citizens are. And that's that last paragraph, right? And they say everybody who lived here at the time, and at the time of the adoption of the Constitution. So again, we're talking about the 1780s. So it's about 80 years earlier, okay, were recognized as citizens of the several states. So if you were a citizen back then, you can be a citizen now. Okay, so they also became citizens of the new political body. So if you were a citizen of a state during the Revolution and that period immediately after, right, then you became a citizen of the new country. Okay? But nobody else did. Nobody else did. It was formed by those folks who were citizens at the time, and for them and their posterity, but for no one else. Posterity means like your kids and your grandkids and on down the line. Okay? For the personal rights and privileges granted to citizens of this new sovereignty were intended to embrace only those who were then members of the several state communities. So the rights they articulate as part of the Bill of Rights, that only counts for those folks who were citizens at the time, right? Or who should afterwards, by birthright, okay, so if your parents were citizens, you became a citizen, or otherwise became members. This is a way of saying naturalized citizens. Okay? According to the provisions of the Constitution and the principles on which it was founded. Okay? So Scott is not a citizen. He doesn't have the right to sue. And at the time, citizen was a very specifically defined term to mean those people who were considered citizens at the time the Constitution was adopted, and their families on down the lines, and people who were added later specifically. It becomes necessary, therefore, and I'm back on the document now, to determine who were citizens of the several states when the Constitution was adopted. The legislation and histories of the times and the language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether they became free or not, were then acknowledged as a part of the people, nor intended to be included in the general words used in that memorable instrument. Okay, so think back to what you remember about the Declaration of Independence, right? We hold these truths to be self-evident, that all men are created equal and brought forth. Okay, all men are created equal. And what he's saying is, well, not really. Not really, right? Slaves were not considered to be men. They were not considered to be people at the time. Okay? And so this is really where he's making that declaration to say, look, black people are not citizens. They were not meant to be citizens at the time. We cannot later construe it to mean that they were citizens. It is difficult at this day, I'm back on the document, to realize the state of public opinion in relation to that unfortunate race, which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence and when the Constitution of the United States was framed and adopted. They had for more than a century before been regarded as beings of an inferior order, altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery. He was bought and sold, and treated as an ordinary article of merchandise and traffic, whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute, and men in every grade and position in society daily and habitually acted upon it in their private pursuits, as well as in matters of public concern, without doubting for a moment the correctness of this opinion. Okay, so we're going to go back up here, right? He says, it's hard to know today what the public opinion was at the time of black people, right? It was hard to know, but he says for more than a century they had been regarded as beings of an inferior order. So they are, again, he's saying, lesser people. They're not seen as equals, okay, and altogether unfit to associate with the white race. So now he's talking about segregation and separation, okay, either in social or political relations. Social relations, interpersonal, like you and I. They're inferior and unfit, Taney says, to be friends with white people, to be in marriages with white people, okay. And political reasons. Now he's talking about our relations. Now he's talking about government. He's saying black people were never meant to be included in the government or as part of the government. And that they were so far inferior, they were so much less than, that black people had no rights which the white man was bound to respect. In other words, we didn't have to respect rights of black people, right? There's nothing that says we have to. That, matter of fact, that phrase right there, that black people have no rights which the white man was bound to respect, that's probably the most famous phrase in the entire decision. Because it is so hardcore, right? It's so far over the top in terms of how he clearly thinks about other people, right? Or the folks that he considers to be other people. Okay. He says, and because we don't have to respect their rights, that's what makes us able to reduce them to slavery. Okay. And then he goes on to say that really what's going on is that white people they're reducing them to slavery and treating them like merchandise. Okay. They're treating them like they're an object and buying and selling whenever they can make a profit. He says this opinion was at the time fixed and universal in the civilized portion of the white race. It's kind of a loaded statement, but basically he's talking about the British and the Americans, maybe the French. He might also include the French in there, right? Maybe some Europeans, but really he's saying everybody thought it at the time. Was regarded as an axiom, right, a self-evident truth in morals as in politics, which nobody argued about. Nobody even thought to argue about. And that's really what the last part of that says, right? That this wasn't under debate at the time. This wasn't under debate at the time, right? Which you and I both know, because we've learned a little bit about the Constitutional Convention, was absolutely debated at the time. Was absolutely debated at the time. All right, back to the text. And in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and the English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them, and were far more extensively engaged in this commerce than any other nation in the world. The opinion thus entertained and acted upon in England was naturally impressed upon the colonies they founded on this side of the Atlantic, and accordingly, a Negro of the African race was regarded by them as an article of property, and held and bought and sold as such in every one of the 13 colonies which united in the Declaration of Independence and afterwards formed the Constitution of the United States. The slaves were more or less numerous in different colonies, as slave labor was found more or less profitable. But no one seems to have doubted the correctness of the prevailing opinion at the time. Okay, so here's your secret for the day, right? Your new bit of knowledge. A lot of American law, especially early American law, was based on what's called English common law. And that's what he's doing here. He's making an appeal to English common law and to that heritage from England. Okay? So he says the English people were the most firm about this. They thought this much more than anybody else. Okay? So they're not only seizing people on the coast of Africa and selling or holding them in slavery for their own use, they're literally taking them as if they were, I don't know, a box of t-shirts to every country where they thought they could make a profit on them. And they were far more extensively engaged in this commerce than any other nation in the world. So they're doing it much, much more than anybody else. Okay? By the way, by the 1850s, the English had one of the biggest colonial empires in the world, and it was still growing. So that's also kind of an appeal to that, right? England literally at its height has colonies all over the world, and the expression was that the sun never set on the British Empire. So they're about halfway, 2/3 of the way there at this point in terms of their colonies, right? So he says they were doing it literally everywhere. right? So because England was doing it, right, they naturally impressed this opinion and these actions on their colonies here in the modern US. Okay? And because they held black people as property, okay, and bought and sold them, that happened in all 13 states, which is true. Okay, all 13 original colonies had slavery at some point. Okay. And that they were more or less numerous in different colonies as slave labor was more or less profitable. Okay. Truthfully, because slave labor is fundamentally free, where you're really just paying enough to keep people alive, so that's not free, but pretty darn close, it would have been a lot more profitable than he's giving it credit for here. Okay. But in the northern states, you start to see those emancipation movements. And indeed, as we go across time, more and more states are emancipating their slaves. Okay. So, but really he's saying, everybody believed it. Nobody doubted it. And nobody thought that it was wrong. More importantly. Okay. The legislation of the different colonies, I'm back on the text here, furnishes positive and indisputable proof of this fact. These laws show too plainly to be misunderstood the degraded condition of this unhappy race. They were still in force when the Revolution began, and are a faithful index to the state of feeling towards the class of persons of whom they speak, and of the position they occupied throughout the 13 colonies, in the eyes and thoughts of the men who framed the Declaration of Independence and established the state constitutions and governments. They show that a perpetual and impassable barrier was intended to be erected between the white race and the one which they had reduced to slavery, and governed as subjects with absolute and despotic power, and which they had then looked upon as so far below them in the scale of created beings, that intermarriages between white persons and Negroes or mulattoes were regarded as unnatural and immoral and punishable as crimes, not only in the parties, but in the person who joined them in marriage. And no distinction in this respect was made between the free Negro or mulatto and the slave, but this stigma of the deepest degradation was fixed upon the whole race. All right, so we're going to pause there again. So the legislation of the different colonies furnishes positive and indisputable proof of this fact. He's talking about the laws. Okay, he's making an appeal to the laws of the colonies at the time. Okay. He says those laws show far too plainly to be misunderstood. Okay, so we can see it clearly, the degraded condition of black people. Right? It says these laws were still in force when the Revolution began, and are a faithful index. So now he's getting into, again, this is how we know, okay, of the feeling toward the class of persons of whom they speak, and of the position that they occupied in the colonies, in the eyes and thoughts of the men who framed the Declaration of Independence and established the state constitutions and governments. It's a fancy schmancy way of saying the Founding Fathers. Okay, he says these laws show us very, very clearly how the Founding Fathers thought about slavery, and their thoughts are the ones that we need to defer to here. Okay. They show that a perpetual and impassable barrier was intended to be erected between the white race and the one which they had reduced to slavery. Okay. Again, segregation. Hardcore segregation is what he's talking about here. We don't want different groups of people mixing. So he's talking about building a wall, metaphorical wall in this case, but a wall nonetheless. Okay. Let's see. And which they then looked upon as so far below them in the scale of created beings that intermarriages between white persons and Negroes or mulatto I'm going to pause there, even though I'm only partway through the sentence. Okay. So this is now the beginning of an appeal to what's called scientific racism. Okay. And you don't need to know a ton about it, but really what you need to know to kind of understand this is that at the time there was a lot of movement in science to classify everything in the natural world. Plants, animals, you name it, right? They're trying to sort it and classify it. Okay. It's that same classification system you learn in biology with Miss Mac. Okay. But they are, he says, so they're regarded as so far below white people, okay, that it's unnatural and immoral. So it's against the laws of nature, and it's, immoral is kind of your fundamental belief systems, right? And when he says Negroes, he's going to be talking about folks who look or appear to be black and directly, like in a direct line. So there's not white ancestors as far as you can tell by looking at folks, which is, again, always a tricky proposition. You and I know that. When he uses the word mulattoes, he's talking about folks of mixed race who have lighter skin. Okay? So he's obliquely acknowledging that there has been, over time, some mixing that has happened, right? He says that these marriages between these groups were punished as crimes, and not just the people who got married, but the person who joined them in marriage, the minister, okay? The minister or the city official, right? Ship captain, whoever, joined them in marriage. So it's so much of a crime that we're going to not just punish the people who are getting married, but the people who are performing the marriage. Okay. And he says there's no difference. When he says there's no distinction, that means no difference in this respect was made between the free Negro or mulatto and the slave. So status free versus slave doesn't matter. Okay. But this stigma, which is really just another way of saying like a mark of shame, okay, of the deepest degradation was fixed upon the whole race. So it applies to everybody. It doesn't matter if they were free or not. It applies to everybody. We refer, and I'm back on the text here, to these historical facts for the purpose of showing the fixed opinions concerning that race upon which the statesmen of that day spoke and acted, in order to determine whether the general terms used in the Constitution of the United States as to the rights of man and the rights of people were intended to include them, or to give to them or their posterity the benefit of any provisions. Right? This is really, we can use these historical facts to tell us whether or not black people were meant to be included under the Constitution. Right? And not just black people at the time of the Constitution, but really their children and grandchildren, right? That's what that word posterity means. All right, and we're back. The language of the Declaration of Independence is equally conclusive. And here he's quoting, okay? We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them is life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted, deriving their just powers from the consent of the governed. The general words above quoted would seem to embrace the whole human family, and if they were used in a similar instrument at this day would be so understood. But it is too clear for dispute that the enslaved African race were not intended to be included, and formed no part of the people who framed and adopted this declaration. For if the language, as understood in that day, would embrace them, the conduct of the distinguished men who framed the Declaration of Independence would have been utterly and flagrantly inconsistent with the principles they asserted, and instead of the sympathy of mankind, to which they so confidently appealed, they would have deserved and received universal rebuke and reprobation. Okay, so we're going to pause there again, right? So he says that the Declaration of Independence let me start again. The Declaration of Independence either lied in writing, right, or they knowingly meant to exclude blacks. So either they're lying, or it didn't occur to them that it would be interpreted any other way. Okay. So we wouldn't agree with this assessment today, okay? But that's what he's saying back then. And remember, the Declaration of Independence is drafted by Thomas Jefferson, who was absolutely a slaveholder, okay? But also by John Adams and Benjamin Franklin, neither of whom were. So Jefferson handles most of the language. Adams and Franklin tweak it around the edges and help with the ideas portion of it. Okay. But what he's saying is that either they lied or it didn't occur to them that blacks would be included as part of this. And I'm not sure I agree with that assessment. Just knowing what I know about the Constitutional Convention and knowing what I know about the discussions that were happening at the time, right? I think Taney's here taking a lot of liberties with what he's saying. Okay. And here, and I definitely don't believe that this is what he thinks, right? But that second full paragraph underneath the quote, he says, if they were to write this today, of course black people would be included as citizens, right? Of course they would. But we're not writing it today, and we need to understand it in the language it was and the ways the words were used at the time, right? How it was meant at the time. And I don't actually believe that this is what Taney thinks. Just for the record. Okay. There's too much else of what he says and the way he says it, and too much else about his background for me to believe that he actually felt that way, right? I think he's throwing some folks a bone, trying to paper over some of the arguments, right? So he says either they lied about what they thought, or it didn't occur to them, right? They knowingly chose to exclude because it just, they figured black folks weren't citizens, he says, right? And if they had meant to include black folks, right, they would have been rebuked. Okay, so rebuked is people would have come out against them and said something. Okay, they would have been received universal rebuke and reprobation. They would have been condemned, is really what he's saying. Okay. All right, back on the text. Yet the men who framed this declaration were great men, high in literary acquirements, high in their sense of honor, and incapable of asserting principles inconsistent with those on which they were acting. They perfectly understood the meaning of the language they used and how it would be understood by others, and they knew that it would not in any part of the civilized world be supposed to embrace the Negro race, which by common consent had been excluded from civilized governments and the family of nations and doomed to slavery. They spoke and acted according to the then established doctrines and principles in the ordinary language of the day. No one misunderstood them. The unhappy black race were separated from white by indelible marks and laws long before established, and were never thought of or spoken of except as property, and when the claims of the owner or the profit of the trader were supposed to need protection. Okay. So he says there's no way these guys would have meant to include blacks as part of that language about citizenship and freedom, right, and rights. That there's no way they could have said one thing and done another thing in their private life, okay? Which is patently untrue. You and I both know everybody at some point says one thing publicly and does another thing privately. That's just the way life works, right? Sometimes big things, sometimes small things, but everybody does it. Everybody does it. Okay? And Thomas Jefferson for sure did, because the Declaration of Independence isn't the only place where he's writing about freedom for blacks. Okay. So he says they understood the words they used and how it would be understood by others. Okay. And they knew that nobody in the civilized world thought that it would include black people. Okay. And the reason they didn't think that, he says, they by common consent had been excluded from civilized governments and the family of nations and doomed to slavery. Okay. Common consent, everybody thought it, right? Everybody agreed to it. They had been excluded. They had not been allowed to join civilized governments and the family of nations. So there were no countries, is kind of what he's saying here, right? And doomed to slavery. Right? He says, they, and now the they is Jefferson, Adams, and Franklin, spoke and acted according to the then established doctrines and principles and in the ordinary language of the day. No one misunderstood them. Okay. They knew what they were saying. Everyone knew what they were saying. The unhappy black race were separated from white by indelible marks. And this now is a reference to, amongst other things, skin color, right? Could also be a reference to thoughts on black mental capacity and things like that. There's a lot to the scientific racism thing, but he's swooping back in here a little bit. Okay. He might also be making a bit of a reference to, there's a biblical theories surrounding what made slavery okay, and a lot of the defenses of slavery you see invoke the Bible and the mark of Ham, if you're familiar with that story. Long story short, Ham is a son of Moses who gets kicked out of civilized society for something that he does. He gets a mark on his face so that people will recognize him and nobody will help him. Okay, and so the argument then becomes that black people are slaves because they are the sons of Ham. All right. Okay. He says that black people were thought of or spoken of as property, with no exceptions. It was universally held. Okay. And that they were, even then, only spoken of when the claims of the owner or the profit of the trader were supposed to need protection. So now again, he's referencing blacks as property. And he's not wrong, incidentally, when we talk about the language of the Constitution. In the Constitution, right, slaves are the only property spoken of explicitly. And they are in a couple of different places. But he's not wrong about this piece in terms of the language of some of the documents at the time. This state of public opinion, now I'm back on the document, had undergone no change when the Constitution was adopted, as is equally evident from its provisions and language. And now he's getting into more of what I was telling you about. There are 2 clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and show clearly that they were not regarded as a portion of the people or citizens of the government then formed. One of these clauses reserves to the, One of these clauses reserves to each of the 13 states the right to import slaves up until the year 1808. And by the other provision which the states pledged themselves to each other to maintain the right of property of the master, and by delivering up to him any slave who may have escaped from service and be found within their respective territories. And these two provisions show conclusively that neither the description of persons therein referred to, nor their descendants, were embraced in any of the other provisions of the Constitution, for certainly these two clauses were not intended to confer on them or their posterity the blessings of liberty, or any of the personal rights so carefully provided for the citizen. All right, so now he's getting back into some of what I was telling you about. Okay, so he says there's two clauses of the Constitution, that's two parts, okay, which point directly and specifically to black people as a separate class of people, okay, and that demonstrate this idea that they were not meant to be included as citizens of the government. Okay. He says the first of these is the clause that allows the states to import slaves until the year 1808, which indeed there's a clause in the Constitution that says that. It's a compromise, right? So kind of enables everybody to have a win. The slave states in the South can continue to bring in slaves. Even at the time of the Constitution being written, there were states that were, if not free, in the process of gradual emancipation in the North, and where people were leaning towards freeing states. Okay, so it's allows for that compromise. He says, and the provision that the states will return slaves to their master if they run away. Okay. So this is the basis of those fugitive slave laws you've been reading. He says, and because of these, we know, right, conclusively, that neither the descriptions of persons therein referred to nor their descendants, okay, so we know neither slaves nor their descendants were embraced in any of the other provisions of the Constitution. For certainly these two clauses were not intended to confer on them or their posterity the blessings of liberty. So because they're specifically referring to black people as slaves, we can then infer, based on strong evidence, that they were not meant to have the same rights and freedoms, right? So carefully provided for the citizen. No one of that race, I'm back on the text here, had ever migrated to the United States voluntarily. All of them had been brought here as articles of merchandise. The number that had been emancipated at that time were but few in comparison with those held in slavery, and they were identified in the public mind with the race to which they belonged, and regarded as a part of the slave population rather than the free. It is obvious that they were not even in the minds of the framers of the Constitution when they were conferring special rights and privileges upon the citizens of a state in every other part of the Union. Okay, so I am going to pick a little bit of a bone with this idea that no black people had ever migrated to the U.S. voluntarily. Right? There are people who are making the decision. There are just very, 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 very few of them. And oftentimes that decision is made under duress, which means, for example, that people are choosing to come here because slavery in the Caribbean was much, much worse. So there are examples of slave rebellions on ships and slaves taking over ships and sailing them for the nearest port in order to try and get home, right? But by far, it's not very many people. Okay, so he's largely but not completely correct there. Okay. The number that had been emancipated, and again, emancipated means freed, at the time were but few in comparison with those held in slavery. He says there are some free people, some free black people at the time, but not very many of them. And they're very, very small in number compared to the number of folks held in slavery. And that in the public mind, in the average person, and here he's thinking average white person, right? They are identified by the race, so they're identified as being black and regarded as a part of the slave population. Okay. He says it's obviously weren't even on the mind of the framers of the Constitution when they were conferring rights and privileges, right? Back on the text here. It would be impossible to enumerate the various laws marking the condition of this race which were passed from time to time after the Revolution, and before and since the adoption of the Constitution of the United States. In addition to those already referred to, it is sufficient to say that Chancellor Kent, whose accuracy in research no one will question, states in his commentaries that in no part of the country except Maine did the African race, in point of fact, participate equally with the whites in the exercise of civil and political rights. Okay, so now he's saying that there's too many laws to list. That's what enumerate means, is to create a list. Okay, marking the condition of black people, which were passed from time to time after the Revolution. Okay. And before and since the adoption of the Constitution of the United States. He says, in addition to those already referred to, so on top of what I've already talked about, okay, it is sufficient to say that Chancellor Kent, and this isn't from the footnote at the bottom of the page, was the Chief Justice of the New York Supreme Court and Chancellor of New York. His written opinions and commentaries on American law were accepted as a standard interpretation of the Constitution. Okay, so he's referring to a big authority, somebody that his readers are going to recognize. Okay. He says, in no part of the country, according to this guy, but Maine, were blacks allowed to participate equally with whites in the exercise of civil and political rights. And it's worth knowing, by the way, right? These days we think of Maine as kind of a very integrated part of the East Coast. But at the time, Maine would have been frontier territory. Okay? There were not cities of any size in Maine, small villages at most. So yes, Maine becomes a state during this early period, but it's not a heavily populated one, and it's very much kind of on the edges or on the frontiers, and that's why it takes them time to become a state, right? And indeed, they were part of New Hampshire up until they became a state. To all this mass of proof, I'm back on the text, we have still to add that Congress has repeatedly legislated upon the same construction of the Constitution that we have given. The first of these acts is the Naturalization Law of March 26, 1790, which confines the right of becoming citizens to aliens being free white persons. Another of the early laws of which we have spoken is the first Militia Law, which was passed in 1792 at the first session of the Second Congress. The language of this law is equally plain and significant. It directs that every free, able-bodied white male citizen shall be enrolled in the militia. The word white is evidently used to exclude the African race, and the word citizen to exclude unnaturalized foreigners, the latter forming no part of the sovereignty, owing it no allegiance, and therefore under no obligation to defend it. The African race, however, born in the country, did owe allegiance to the government, whether they were slave or free, but it is repudiated and rejected from the duties and obligations of citizenship in marked language. Right, so here he's adding some examples, right? That's what he means when he says, to all this mass of proof we have still to add. So I've already given you a whole bunch of proof, a whole bunch of evidence, but I'm going to add some more, okay? Because he says Congress has repeatedly passed laws that demonstrate what I'm saying, okay? Or what we're saying, because he's writing for the majority, okay? So the first of these laws is a naturalization law. Naturalization is the process by which you become a citizen, right? You either become a citizen by birthright or by naturalization. Birthright means that you were born a citizen, and naturalization means that you chose to become one at some later point of your life. Okay. Which confines the right of becoming citizens to aliens being free white persons. Aliens means non-citizens, right? It means foreigners. and then specifies free white persons. Okay. Another of the early laws of which we have spoken is the first militia law. Militias are, if you've never heard that term, probably the best example and the way in which he's using that word militia, because it's got some slightly different meanings now, would be to think of like National Guard, like the state National Guard. Okay. It says, which was passed in 1792 at the first session of the Second Congress. And he says it's equally plain and significant. Okay? So it's giving us still more strong evidence. And he quotes free, able-bodied white male citizen. He pulls out that little bit of text from the longer law. Okay. He says they have to be enrolled in the militia. That's what the law says, right? White excludes blacks, excludes free or enslaved blacks. Okay. And the word citizen means unnaturalized foreigners. So people who have not yet become citizens of the United States. The latter, and now he's talking about the foreigners, right? The folks who have not been naturalized, forming no part of the sovereignty and owing it no allegiance. So he says they're not part of the government. They don't owe any allegiance to the government, right? Therefore, they don't have to defend it. They're under no obligation to do so. Okay. And this law that he's talking about, by the way, is much like a draft. That's really what he's saying. Okay. So it's a draft law, and if you're not a citizen of the government, you don't owe the government an obligation to help protect it or help defend it. Okay. The word white, the African race, however, born in this country, did owe allegiance to the government. So he says, because now we're dealing with folks, he's assuming everybody's born here, that everybody was obeying that 1808 law, right? Or 1808 mandate from the Constitution. You and I both know that's malarkey. Okay. But he's going to pretend like nobody's breaking the law and importing slaves directly from Africa. Okay. He says, did owe allegiance to the government, whether slave or free. So your status didn't matter in terms of whether you were slave or free. But it is repudiated, right? It means it's untrue and rejected from the duties and obligations of citizenship in marked language. So there's an implication that that blacks would owe allegiance to the government, right? But it is clearly called out that they are rejected from the duties and obligations of citizenship. Okay? So they are not expected to perform the things citizens would be expected to perform. All right, back on the text here. The third act, to which we've alluded, is even still more decisive. It was passed as late as 1813, and it provides that from and after the termination of the war in which the United States are now engaged with Great Britain, it shall not be lawful to employ on board of any public or private vessels of the United States any person or persons except citizens of the United States or persons of color natives of the United States. Here, the line of distinction is drawn in express words. Persons of color, in the judgment of Congress, were not included in the word citizens, and they are not described as they are described as another and different class of persons authorized to be employed if born in the United States. All right, so he's going to give us a third example here. All right, and the law he's referring to is one that was passed during the War of 1812, which we didn't study. Okay. I think it mentioned it briefly in the text, but it's not a big war that's super common for folks to spend a lot of time on. Okay, so he says that law provides that it shall not be lawful to employ on board public or private vessels of the United States any person or persons except citizens of the United States or persons of color, natives of the United States. Okay. And here is the line of distinction drawn in express words. Here, they could not say it any more clearly, he says. Right? It's very, very clear what the legislature has in mind. Right? In the judgment of Congress, persons of color were not included in the word citizens. So black people are not citizens according to Congress based on a plain reading of this law. Okay. They're described as another and different class of people, but are still authorized to be employed if born in the United States. And by the way, when they say natives of the United States, that's what they mean, is folks who were born in the United States. Okay, that's the way they're going to use that terminology. All right. No one, we presume, and I'm back on the text here, supposes that any change in public opinion or feeling in relation to this unfortunate race in these civilized nations of Europe or in this country should induce the court to give to the words of the Constitution a more liberal construction in their favor than they were intended to bear when the instrument was framed and adopted. Such an argument would be altogether inadmissible in any tribunal called on to interpret it. If any of its provisions are deemed unjust, there is a mode prescribed in the instrument itself by which it may be amended. But while it remains unaltered, it must be construed now as it was understood at the time of its adoption. It is not only the same in words, but the same in meaning, and delegates the same powers to the government, and reserves and secures the same rights and privileges to the citizen. And as long as it continues to exist in its present form, it speaks not only in the same words, but with the same meaning and intent with which it spoke when it came from the hands of its framers, and was voted on and adopted by the people of the United States. Any other rule of construction would abrogate the judicial character of this court, and make it the mere reflex of the popular opinion or passion of the day. This court was not created by the Constitution for such purposes. For such purposes. Higher and graver trusts have been confided to it, and it must not falter in the path of duty. Okay, and so here, what Taney's getting into is some discussion of different arguments that have been going on, still go on today, about how to interpret the Constitution. Okay? And what he's saying is, no one, we believe, right? We presume, he's saying we believe, supposes that any change in public opinion or feeling would cause the court to give to the words of the Constitution a more liberal construction. So a more liberal in this sense in the way we use it today. Okay. But a more loose construction in their favor than they were intended to bear when the instrument was framed and adopted. Okay. So he's saying, we don't think anybody would think we should go beyond what was intended in the 1780s when this was adopted. Such an argument would be altogether inadmissible in any tribunal, any court of law, right, called on to interpret it. It says, you could not ask the courts to do this. If you think that this interpretation is unfair or unjust, right, there is a way to modify the Constitution, and you should do it. Okay. But while it remains unmodified, we have to interpret it how it was interpreted at the time of its adoption. So now he's saying his hands are tied, right? He says if you want to change it, change it. And ultimately we do that with the Reconstruction Amendments. But he says for right now, this is what it says and this is what it meant. Okay? He says we have to stick to what they meant at the time. Okay? Because any other rule of construction, any other way of understanding it, would abrogate which is really just a fancy schmancy way of saying it would abolish or get rid of the judicial character of this court and make it the mere reflex of the popular opinion or passions of the day. So he says, if we don't interpret it like it was meant at the time, really what we're doing is we're just going to kind of be going with the flow, and that flow is going to change across time, right? And the tone tells us that he believes this would be a very bad thing. And he kind of goes on to hint at that. He says it not quite directly, but pretty close. Okay. This court was not created by the Constitution for such purposes. Higher and graver trusts have been confided to it, and it must not falter in the path of duty. So he says, look, that's kind of what he's trying to say here, right? We can't just reflect the passions of the day. We have a higher duty. We have to obey the Constitution as written, okay? And we cannot falter from that. All right, back to the text. And upon a full and careful consideration of the subject, the court is of the opinion that Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States, and not entitled as such to sue in its courts, and consequently that the circuit court had no jurisdiction of the case, and that judgment on the plea in abatement is erroneous. It appears affirmatively on the record that he is not a citizen, and consequently his suit against Sanford was not a suit between citizens of different states, and the court had no authority to pass any judgment between the parties. This suit ought, in this view of it, to have been dismissed by the circuit court, and its judgment in favor of Sanford is erroneous and must be reversed. So he says, Dred Scott's not a citizen. Because he's a citizen, he can't sue. Okay. And because he cannot sue, the circuit court, which is a lower level court, that's just like your basic court, right? He says, should never have agreed to rule on this case. It ought to have dismissed it. Okay. And because it should have dismissed it, the judgment in favor of Sanford is erroneous, is wrong, right? And must be reversed. We have to overturn it. But there's another point in the case, back on the text here, which depends on state power and state law. And it is contended on the part of the plaintiff that he is made free by being taken to Rock Island in the state of Illinois, independently of his residence in the territory of the United States. And being so made free, he was not again reduced to a state of slavery by being brought back to Missouri. Our notice on this part of the case will be very brief, for the principle on which it depends was decided in this court upon much consideration in the case of Strader et al. V. Graham, 1850. In that case, the slave had been taken from Kentucky to Ohio with the consent of the owner and afterwards brought back to Kentucky. All right, so here he says so that was part one, but there's another piece we need to talk about. We're going to do it quickly, he says. Okay, and he says that we have to deal with this issue of slaves crossing lines, okay, and whether or not they're free when they go to the free territories, but then become enslaved again when they are brought back into slave territories. Okay. It says we'll be very brief about this. This has already been dealt with. And here, what he's doing is he's relying on a doctrine, on a rule called stare decisis, which is a Latin term, but really what it means is it's already been decided and we're going to rely on that. Okay. We're not going to complicate things by changing our minds, even though it was a while ago. Okay. And so he quotes this case, Strader et al. V. Graham, which was decided in 1850. And now we started to give you some of the details of the case, right? All right, so back to the text, because we're almost done. And this court held that their status or condition as free or slaves, so this is Strader et al., okay, depended upon the laws of Kentucky when they were brought back into that state, and not of Ohio, and that this court had no jurisdiction to revise the judgment of a state court upon its own laws. This was the point directly before the court, and the decision that this court had no jurisdiction turned upon it, as will be seen by the report of the case. So in this case, as Scott was a slave when taken into the state of Illinois by his owner, and was there held as such, and brought back in that character, his status free or slave depended on the laws of Missouri and not of Illinois. Okay, so now what he's saying, right? So he's continuing his summary in that first little bit. Okay, he says, but we have to rely on the laws of Kentucky, not of Ohio. Helps if you know a little bit about your geography and you know Kentucky and Ohio are right next to each other. Okay, they're just across the Ohio River from each other. Right? But he says, this court had no jurisdiction to revise the judgment of a state court upon its own laws. In other words, we didn't have the right to make a decision about how a state court decided on state laws. That was the point before the court, and we decided that we didn't have that right. It says it's the same thing with this case. It says the basics are fundamentally the same. Upon the whole, therefore, it is the judgment of this court that it appears by the record before us that the plaintiff in error is not a citizen of Missouri, in the sense in which that word is used in the Constitution, and that the Circuit Court of the United States, for that reason, had no jurisdiction in this case and could give no judgment upon it. Its judgment for the defendant must consequently be reversed and a mandate be issued, directing the suit to be dismissed for want of jurisdiction. So now he's really just summarizing, right? He says, Scott wasn't a citizen in the sense that word was used at the time the Constitution was adopted, right? And is not now a citizen. And that because of that, the circuit court had no jurisdiction, so they could not make a judgment because he wasn't a citizen of the United States, right? And so we have to return this decision and reverse it and say that Sanford wins. Okay, that Scott had no right to sue. All right, so that is the Dred Scott decision. Go ahead and read the questions at the bottom there, because those are the ones that we're going to use on the quiz that you're going to take over this for this week. All right, I'll see you later.